There has been a lot of buzz about AI taking away professional jobs, including that of lawyers, doctors, software engineers, and professions across the board. And predictions are coming out faster than the tools are being developed themselves. So I decided to sit down and see for myself. So, firstly, this is not a doomsday post about AI taking away legal jobs, but rather about how tools are helping litigants like me stay abreast of the process, the arguments, the counter arguments, but also the limitations of the tools. A while ago, I had shared my story of litigating with local revenue department officials. And this has been going on for a very long time over a title update issue. And during the 6, 7 years that I've taken the revenue officials to high court several times, and every time got favorable judgments. However, they continue to drag their feet, giving frivolous excuses, hoping that I will simply pay the bribe and have the matter resolved. But I'm not giving up. So, it currently stands, there is a contempt of court filing against the local officials pending in the High Court, and the hearing is scheduled for early next month. And likewise, my lawyer has filed the latest writ against government officials and the BDA pertaining to the land acquisition that might happen. So now, what I decided to do is this. On the buzz about the legal plugin from Claude.AI, I decided to check it out for myself. I took a copy of the detailed 30-page writ petition filed by my lawyer and uploaded it to Claude's AI to learn the what if about arguments that could be made by the government attorney. So I was blown away by the 15 to 20 detailed points with counter arguments that I could learn from. 15 to 20 arguments with detailed points being made here. Now, while I was blown away by these points, the points here seem to take inputs from my petition, but lack the detail of the context. For example, if you take this point here, now it says at the time of both the primary and the final notification, property was recorded as a Karigoma. And the revenue mutation in favor of the original grantee occurred only Jan 25, well after the acquisition process began, which is partly true, but this is again because of the inaction by the government authorities to act on an earlier petition. This model does not have the context that myself and my lawyer have. So it has just given the bullet points based on what it's seeing in the current petition, not the references or the citations or the details. And that is where our knowledge comes in. So this is one example. So what I did is I went through these detailed points and decided to further ask questions. So I said, can you share similar cases where petitioners have won against PD? So it gave me several citations. And a couple of citations had already been used by my lawyer in his argument in preparing the writ. So it's kind of double checking that effort, right? Now, the other interesting point is I took this further and said, can you share similar cases where petitioners have won against BDA's Shivram Karnat layout land acquisition, specifically pertaining to this area? Now, it brought up detailed citations from earlier, say 2014 to 17, and then the reason why the petitioners won. Again, something that my lawyer had already done the homework on, and we decided to re-review this. Now, these were pretty interesting to understand in terms of the context. Tool is pretty slick, pretty detailed, and has a lot of data and analysis. Having worked with my lawyer during the filings of petitions, arguments, and having attended virtual hearings and even attended hearings in live and high court, I realized that there's a lot more to a legal petition than a simple document. And the arguments are not just what is in the document, but how it is made. So there's a lot of homework that happens before the matter is even heard or comes in front of the judge. Copies have to be made, drafted, and submitted in a certain order. Citations and the language has to be legal and detailed and thorough. Copies of the documents and the citations have to be filed and also shared with the lawyers of the opposing party. Now, the case argument may take just a few minutes when you're prepared, but the actual argument has to be well thought of. And the counter argument happens in split second in front of the law, front of the court. Now, the judge is hearing maybe 40, 50 matters during the course of a day, during during legal proceedings. So they have only a few minutes to get to the heart of the issue. Lawyer, a qualified, experienced lawyer, brings up the heart of the matter, makes the argument, arguments all in a matter of few minutes, and boom, it's done. A judgment is made. And then they move on to the next. So all this comes from years of experience and the ability to read the room, which only an experienced lawyer has. And we as litigants can learn from this, learn from these citations, learn from the process, like I did using the example of Claude, and be better informed while working with the professional like lawyer. But the role of the lawyer or the judiciary or the system is not going away anytime soon. This is my experience.